Good evening. Preliminary remarks while we wait for Judge West to come back and join us and while you all finish getting your food. So I'd like to thank you all for coming out tonight. Welcome to the panel of discussion on felon voting rights, co-sponsored by the Federalist Society and the Center for Global Justice, Human Rights, and the Rule of Law. My name is Chris Hollinger. I'm the president of the Regent Federalist Society. Thank you all for coming out. We are, I'm kind of doing my best Dean Reuter impersonation here because we're doing hopefully a FedSoc podcast out of this event. So I'd like to remind everyone in the room here that the opinions expressed tonight are those of the panelists, not necessarily those of the Federalist Society or of Regent University. And your remarks are being recorded for use as a podcast later. It's also being live streamed and the link is published on our webpage, on our Facebook page if you need to get the link. A couple of share with everybody. On the 22nd of November, we're going to have a panel on concealed carry on campus. Again, an academic discussion with the opinions of the speakers being their own and not necessarily that of the university. That panel will be moderated by our own Dean Patterson of the government school, and the participants will be Professor McKee from the School of Law, who many of you know, and then also Professor Gregory Wallace from Campbell University. So that'll be right in the same place at the same time, Tuesday, November 22nd at 5:30, right here with dinner provided. Still working on the food. We haven't made a decision on the food yet, but it will be good, once again, I can assure you. In conjunction with that event, we're also looking at doing a celebration of the Second Amendment, perhaps on either the last day of classes or the first day of the reading period. We'll be going out and getting some range time in and celebrating our right to keep and bear arms together. Next semester, we are looking at co-sponsoring a panel with BALSA on diversity, what diversity is to us, and then also co-sponsoring a panel with the Center for Global Justice during their symposium the first week of March on immigration reform. I think we're still working on the details on that one, but we'll be co-sponsoring another panel with the center, and then we'll have at least two other big FedSoc events. So, we're here tonight to talk about the restoration of voting rights for felons. As many of you know, Governor McAuliffe, over the course of this year, had attempted to restore voting rights for over 200,000 convicted felons who had completed their sentences and returned to society. And that action initiated a legal battle, which culminated at the Virginia Supreme Court in July in a decision, and the case was Howell versus McAuliffe, where the Virginia Supreme Court decided that the governor's actions were a violation of the Virginia Constitution, specifically the anti-suspension provision of the Virginia Constitution. So, our speakers tonight are going to discuss the legal and policy-related questions that arise out of the felon voting rights actions that the governor took. So we're going to look at things like, should the governor have done it this way? Is the policy of restoring voting rights to felons a good public policy matter? Or is it maybe something that shouldn't happen? And if so, what's the proper way to do it? We are going to be hearing from three panelists. We've got Mr. Hans von Spakovsky from Heritage, Ms. Hope Amezquita from the ACLU, and Mr. Jesse Weiss from Prison Fellowship, and Judge West will read fuller introductions of each of them as soon as I get done. Our moderator for tonight is Regent's own very own Judge Patricia West. And before I introduce her, I'll make just one or two more quick administrative announcements. I understand that there are several folks that have an evidence class at 6:45. So we realize that there may be a little bit of an exodus at about 6:40 to get to evidence. If you have to do that, that's okay. We should be done with the formal part of the presentation by then, and we'll be in the Q&A time. So there'll be time for questions, and if you have to get up and leave at that point, please just do so as quietly as you can and proceed on to evidence and give our best regards to Professor Duane. As you leave, please use the large trash cans to discard of your food trash, not the smaller trash cans. These are the ones for special events. We'll take care of emptying those. And I think that's it. Any other admin that I'm missing? Anybody? If you need to sign in for extra credit for Professor Dysart's class, the sheet's down here. And there's also other Federalist Society literature and that kind of thing. If you're looking for more info about FedSoc, you can sign up to get on our mailing list. So, With that, I will turn things over to Judge Patricia West, who began her career as a law clerk to the Honorable Sam W. Coleman on the Court of Appeals of Virginia. She's worked in the Virginia Beach City Attorney's Office and the Virginia Beach and Norfolk Commonwealth's Attorney's Offices, specializing in child abuse and neglect cases in all of those offices. Judge West has also served as the Secretary of Public Safety under former Governor George Allen, and she's been a judge on both the Virginia Beach Juvenile and Domestic Relations Court and the Virginia Beach Circuit Court. Most recently, she was a Deputy Attorney General of Virginia before she came to Regent, and she's been on the Board of Visitors here at Regent since 2003. She currently serves as our Associate Dean of Career and Alumni Services here at Regent. So Judge West is our moderator for the evening.
All right, I have the honor of introducing our panel tonight. We have three very distinguished guests who will be addressing these issues for you. The first, closest to my left, is Hans von Spakovsky. I've asked each one of them if I can call them after I get their names out by their first names, and they've all agreed. So, Hans is a senior legal fellow at the Heritage Foundation's Edwin Meese III Center for Legal and Judicial Studies. He's the manager of the think tank's Electoral Law Reform Initiative. Hans studies and writes about campaign finance restrictions, voter fraud, and voter ID enforcement of federal voting rights laws. Also, administration of elections and voting equipment standards. Before joining Heritage in 2008, Hans served 2 years as a member of the Federal Election Commission and previously worked with the Justice Department as counsel to the Assistant Attorney General for Civil Rights. He provided expertise in enforcing the Voting Rights Act and helped America Vote Act of 2002. His analysis and commentary have appeared in numerous print and broadcast media outlets, including the Wall Street Journal, the Washington Times, Politico, and several national and regional TV and radio news outlets. So let's welcome Mr. von Spakovsky. Next to Hans is Jesse Weiss, who has served over 7 years in the Iowa prison system and subsequently earned his Juris Doctorate degree right here at Regent University. Some of you may know he's been on campus before and spoke to us before. Great friend of the university. He is a national speaker and advocate for criminal justice reform and the value of people who have been through the criminal justice system, and has made several appearances here at Regent in cooperation with the Center for Global Justice and Human Rights and the Rule of Law. Jesse currently serves as the Director of Community Engagement at Prison Fellowship. So thank you, Jesse, for being here. And furthest to my left is Hope Umestica, and she's the staff attorney and legislative counsel for the American Civil Liberties Union of Virginia. She litigates on a variety of civil liberties and civil rights issues with a focus on prisoners' rights and voting rights. Additionally, Hope serves as counsel to the policy and communication teams of the ACLU of Virginia. She serves as an advocate for the Virginia General Assembly and regulatory agencies on legislation and regulations affecting voting rights. She's a member and volunteer of the Virginia State Bar and the Virginia Bar Association. Hope is also a member of the Hispanic Bar Association of Virginia, the Ohio State University Alumni Association, and the Ohio State University Alumni Club of Greater Richmond, Virginia. She graduated from the Ohio State University of Moritz College of Law and received a Public Service Fellow with the Dean's Special Recognition Award. She also graduated from the Ohio State University cum laude with a BA degree in Political Science and minor in Latin Studies. Thank you, Hope, for being here. The way the panel will work tonight is that each of our guests will open with about 10 minutes of comments, and then I will give each of them time to respond to the other's comments, and at that point in time, we will then start taking questions from the audience. So thank you, and we'll just go right down the table. Hans?
But before getting to the issue, I did want to say, since we have a crowd of law students here today, and if you are looking for an internship, I just want to be sure you are aware that the Heritage Foundation, where I work, has a very extensive internship program. It goes on all year. We have a summer, fall, winter, and spring program, and if you're interested, I encourage you to apply for it. The legal center where I work, we hire between 4 and 5 interns, and the other interns are spread out throughout the other areas of the Heritage Foundation, which is known as the nation's largest conservative think tank. So you can end up working on domestic policy issues, foreign policy issues, religious freedom issues, all kinds of things. I encourage you to apply for that. There's information on the website. And I would tell you there are three big advantages to the Heritage internship. The first is we actually pay you, which is different from a lot of Washington internships. Second, you do real work. The interns that work for me in the legal center do a lot of research and writing on legal issues of all kinds. And finally, I think the most important is that we actually provide housing for our interns, which, as expensive as Washington is, a big deal. So I encourage you to apply for that. We're here to talk about felon voting today, and I'm going to talk about it to make just a couple of points. One on the constitutional issue, the legal issue, and then the policy issue. Look, there are many consequences to a felony conviction, which is when you intentionally and knowingly decide to violate the law. Many people think that your only punishment is that you go to prison. That's not true. Our civil society has decided that you will also suffer a number of other punishments. And those punishments are the losses of certain civil rights. Now, we're talking about restoration of voting rights, but I often find that those in favor of restoring those voting rights never mention the fact that you lose many other civil rights, such as your Second Amendment right, your right to own and possess a gun. You lose your right to sit on a jury. You lose your right to run for public office. In Virginia, you lose your right to be a notary public, perhaps a little more minor, but also another issue. And in many states, you lose many other rights also. Some places you can't get a job as a law enforcement officer. You can't get a job as a school teacher. There are many occupational licenses that you lose the ability to get. So when we're talking about restoring voting rights, don't forget that there's other rights that are also lost. Now, the other thing that is absolutely clear, except to certain members of Congress, is that this is entirely up to the states to decide. That is, whether or not you lose your right to vote when you are convicted of a felony. The 14th Amendment, which is one of the Reconstruction Amendments, clearly gave states the ability to make this decision. The 14th Amendment specifically says the states can abridge the right to vote, quote, for participation in rebellion or other crime. Now, the court decisions over the years have said that the limitation on this is you can't take away people's right to vote for misdemeanors. It has to be felonies. It has to be a serious crime. And the other limitation imposed by the U.S. Supreme Court in more than one case is that if the law that the state passes was done and shaped with an intention to discriminate on a racial basis, that also is against the Constitution and can't be done. Now, you often will, and so the end result of that is that each state's made their own decision. In 48 states, incarcerated felons cannot vote. In 2 states in the country, incarcerated felons can actually vote from prison. That's Vermont and Maine. There used to be a 3rd state, Massachusetts, and about a little more than a decade ago, that right was taken away in a referendum, overwhelmingly approved by the voters of Massachusetts, which, as you all know, is a blue state, fairly liberal, but the people there did not believe it was a good idea for people who are in prison and who have consciously decided to violate the law, that they should be able to shape what the law will be through the voting process. Also, what happened was some prisoners in the state penitentiary actually formed a political action committee, a PAC, to lobby the state legislature, and that got people pretty upset, and that's what kind of brought this to the fore. Now, in most of the states, you automatically have your vote to right restored when you get out of prison and have finished parole and other supervised conditions of your release. But in a number of states, Virginia is one of them, Florida is another, Alabama is another, you actually have to apply to get your voting and other civil rights back. You should be aware that the claims that are made that all of these laws that exist today are there and were put in place as a way of discriminating on the basis of race. Historically, that is not true. The majority of United States members of states in the Union took away your right to vote before the American Civil War. That was certainly the case in Virginia, and this goes back to the 1830 Constitution of the state. And of course, at that time, African Americans could not not vote. The idea of taking away a criminal's right to vote, in fact, goes back to ancient times. It goes all the way back to Greece and Rome. And for those who think that this is just my opinion, I want to give you a quick quote from a Ninth Circuit case. The Ninth Circuit is not exactly the most conservative appeals court in the country. But look, within the last decade, lawsuits were filed all over the country trying to toss out these felon disenfranchisement laws, saying that they were discriminatory, racially discriminatory under the Voting Rights Act. Every one of the cases lost. They lost in the 11th Circuit, the 2nd Circuit, the 1st Circuit, and in the 9th Circuit. And in the 9th Circuit, in the case called Farrakhan versus Gregor in 2010, the 9th Circuit said this, quote, felon disenfranchisement laws have a long history in the United States. These laws predate the Jim Crow era and, with a few notable exceptions, have not been adopted based on racial considerations. Now, the exceptions were in 5 states, including Alabama's, who changed their laws after the Civil War. And Alabama added in a phrase saying that they could take away your right to vote, not just for a serious felony conviction, but also if you were convicted of a crime of moral turpitude. Jesse, I don't know if you know what moral turpitude is? I don't.
I've had people tell me.
Yeah, you're right. So the point of that law, of course, was so that the officials would have the discretion to be able to decide who they could throw out. All of those laws have been thrown out in the courts in lawsuits filed in the 60s and 1970s. So the only laws remaining are those where there is absolutely no evidence they were put in place in order to discriminate. That is certainly true in Virginia. The Constitution we labor under today was passed in 1971. And is there a single person in this room who doubts that if there was one iota of evidence that that provision in 1971 was adopted with an intent to discriminate, that there would not have been a lawsuit, just like the successful lawsuits against Alabama, to toss it out? Well, there's never been a lawsuit like that filed, and obviously the provision is here today. So it is not a discriminatory provision. Now, I will tell you that I don't believe that people should be disenfranchised for life. Okay, I don't think your right to vote should be taken away for all of your life. But I do think that having a waiting period and having an application process is a good idea. Before I came over today, I pulled 2 reports. One is from the U.S. Department of Justice Bureau of Justice Statistics. If you do research in the criminal area, I'd recommend you go there. They have many really good reports. The recidivism rate of felons is extremely high. It's one of the problems in our society. 2/3 nationally are rearrested within 3 years, 3/4 within 5 years. I also pulled the January report from this year from the Virginia Department of Corrections. 48% of Virginia felons are reconvicted within 3 years. So having a waiting period, as Virginia used to, for example, 3 years for nonviolent crimes, 5 years for violent crimes, that actually does 2 things. One, it gives us, society, the opportunity to see whether that felon really has turned over a new leaf, whether they have stopped the behavior that caused them to be in prison in the first place. And second, it gives them an incentive to, in fact, turn over a new leaf and a new way of life and not continue the bad habits and the bad intentional behavior that got them in trouble in the first place. Because they know that if they do that, they keep a clean record, then at the end of 3 years or 5 years, they have the ability to get their voting rights and other civil rights back. And I would tell you that I think it's quite telling that in the executive order that was issued by Governor McCollum, which the Supreme Court of Virginia said was unconstitutional because he went beyond his power by issuing a blanket restoration order. He did restore not only the right to vote, he also restored the right to sit in the jury box and the right to run for public office. But he very specifically said in that order that he was not in any way restoring the right to own or possess a gun. And, that makes me wonder about his claim that he's really wants to rehabilitate these folks and he trusts them now and wants to reintegrate society, because it tells me that while he trusts them in the jury box, he trusts them in the ballot booth, he doesn't trust them out in the community when it comes to their Second Amendment rights. And I think that casts a shadow on his motives in the case. I will end by saying that I do think that the Supreme Court of Virginia got it right when they said that the governor had acted beyond his authority. There's no question that the Virginia Constitution gives the governor the power on an individual basis to commute and pardon anyone convicted of crimes in the state of Virginia. But if you read the order and you look at the history of this, look, in 2010, the ACLU sent a request to Governor Tim Kaine, the Democratic governor of the state, who, as you know today, is the vice presidential candidate for president, and asked him to do exactly what Governor McCollum did. His lawyer sent a letter back in 2010 saying, look, the governor really would like to do this, but the governor does not have the authority and power of the Virginia Constitution to issue a blanket restoration to all felons in the state. Ken Cuccinelli, who was also concerned over this issue, actually formed a bipartisan committee to look at this issue and to determine what is the power of the state government in this area. It was bipartisan. It included advisors, lawyers who'd been advisors to Governor Wilder, first African-American governor of the state of Virginia. I believe the first African-American governor elected in the country. And they concluded that the governor did not have the power to do this on a blanket basis. He does have the power to do it on an individual case-by-case basis. And I would tell you that I think that's the best way to do it, both in terms of staying within what the Constitution and the law says, and also from a policy perspective, being the best way of giving an incentive to felons to turn their life around. Thanks.
Thank you. Jesse?
Well, this is going to be fun. I think I have the best seat at the table because I'm going to get to disagree with my colleague Hans and agree with my colleague Hans, and same with left on the left with Hope here. So I work for Prison Fellowship, and that's the fun part about being missional, being mission-oriented, and we can kind of agree with both political parties and disagree at the same time. So I have a fun job. But I was thinking about what to talk about today, and I love being on these panels when I'm the only one who's been through the criminal justice system. I know I have a couple friends in the audience, so maybe you can back me up if I get into trouble here. But I just want to hit on a couple things of what Hans said, talking about first about collateral consequences in the United States. So there's over 44,000 collateral consequences of a criminal conviction in the United States. So what that means is there are 44,000 status-related, it's a status-related charge or offense that is attached to you as soon as you come through the criminal justice system. So as soon as your status changes in the United States from a quote-unquote upright citizen to a misdemeanor or a felon, these collateral consequences get attached to you. And as Hans was mentioning some of them, you can't vote, obviously, which is what this discussion is about. You may not be able to get occupational licensing. You have difficulty getting housing, especially public assistance housing. Volunteering. The list goes on and on and on. The story I like to tell is from a 75-year-old man in Minnesota who tried to volunteer at a hospice center. He was convicted of a drug conviction when he was 25. So 50 years. And he's trying to volunteer at a hospice center, and I'm sure they have a long line of people waiting to volunteer, and they deny him his ability to volunteer. So, but my point here is what Hans was saying is lots of these things, yes, but as a civil society, I don't believe that we've agreed to those. You don't plead guilty to them when you walk into a criminal court. The judge doesn't know all of them. The prosecuting attorney doesn't know all of them. Your defense attorney doesn't know all of them. And the defendant sure doesn't know all of them. So when you walk into the criminal justice system in the United States and you plead guilty, you may or may not know that the ability for you to vote is compromised. Nobody's going to tell you that. In some states, criminal defense attorneys, because of the Sixth Amendment, they are required to tell you certain things. But there is no way that they can cover the long list of sanctions that will be put against you. So my response is that as a society, we have not determined that. Individual agencies have determined that. Boards have determined that. Individual people have determined that. As a culture, maybe we have individually determined that. As a civil society, we have not through due process determined what we're going to take away from a person apart from their liberty or their freedom of their life. So this is an issue, a large issue in this country. Currently, we have 65 million adults in the United States that have a criminal record. That's 1 in 4 adults. 25% of the American population have been through the criminal justice, have been arrested, their thumbprint has been taken. They have direct experience with the criminal justice system. And, there is, on the voting issue, there's over 6 million people total that are disenfranchised across the country. And Hans was saying 2 states, there's no restriction at all, that you can vote while you're in prison. 15 restrict if you're in prison, but once you get out of prison, you can vote. 4 states, prison plus parole, so after you get out of prison, which is your parole period, after you finish parole, you're automatically restored. 18 states, prison plus parole plus probation, so it's varying, And I know for me, for example, in my case, so in 2005, Governor Vilsack in Iowa, so I get out of prison in 2006. In 2005, Governor Vilsack signs an executive order that says as soon as a person completes his or her parole, their voting rights, their civil rights are automatically restored, except for your gun rights. Great. I'm thinking I'm great. I get released in 2006. I get off parole in 2010. I'm here at Regent University. I'm thinking I got my voting rights back. It's all by executive order. There's no process that you have to fill out. There's nothing that you have to do. So I go before the Virginia Board of Arts. They say, do you have your civil rights restored? I said, I sure do. It's based on this executive order. Well, I started doing some research and found out in 2011, Governor Branstad revoked that executive order. So even though I found myself in that time frame between 2005 and 2011, I should qualify under the executive order. There's no paperwork, there's nothing. So now I'm stuck trying to talk to the Virginia Board of Bar Chambers, trying to convince them that yes, I do in fact have my civil rights back, but because it becomes a political football, I get caught in the middle. So now I have to petition Governor Branstad. I get a lawyer. We send a whole other application process. And little did I know that he hasn't granted anybody their voting rights back at that time. So by the time he did grant me my voting rights, but I found out I was one of 12 people in the state of Iowa. And so my question is why? Like, what makes me so much better? Because I have a lawyer? I mean, why does it have to be so subjective? Who says that the executive branch is actually the proper branch to give and take away voting rights? Maybe it's the legislative branch. Maybe it should be decided by referendum. Maybe it should be the people. Because as Hans said, even in Massachusetts, when they said you shouldn't vote while you're in prison, the New York Times poll just says that our society is heavily in favor of giving people back their right to vote once their punishment is completed. And so these are very, very important questions that really come down to the value and dignity of people that come through the criminal justice system. And I'm here to say that people who go through the criminal justice system are people like you. They're just people. And they find themselves in the criminal justice system. Now, not that they just find themselves there by mistake. Most people put themselves there by intentional actions, like I did. But that doesn't mean that I can't pay back what I owe. It doesn't mean that I should always be in perpetuity dangling the carrot in front of me, as I feel like Hans is suggesting, just give them the 3 years. Well, I'm telling you, there's no other carrots. Everything is being, so you're telling me to get a job, but wait, you can't get a job. Well, if you get a job, for 3 years, after 3 years, maybe, it goes on and on and on. And it's this perpetual punishment that we have in this country that's problematic. And when we do have high recidivism rates, I wonder, we can't just look at the rate, we gotta look at why. Why are people recidivating? Is it because of all of these things that we're putting people down? And, I just really want to also just talk about, the political part of this issue. I don't know how many are familiar with a term called prison gerrymandering. But when we talk about politicizing people who are in prison or politicizing the vote. What prison gerrymandering is when the census takes, the Census Bureau takes a census and they divide, what am I trying to say? Voting regions, voting areas, districts, right, based on population. But when they look at a prison, the rules of the Bureau or states are, well, the state rules or state laws basically say that if you're in prison, you need to be, you aren't counted as if you're in prison, you're counted where you live. Okay? But what happens in prison gerrymandering is that the Census Bureau overlooks that, and they count people where they're in prison. So what that means is in districts that have a high population of people in prison, even though they can't vote, what it does is it makes the people in that district, it makes their vote more than a person who's in a district that doesn't have a prison. So, for example, if you take like a district in Texas that had 12% of its population in that district were incarcerated. Well, none of those people count. So 88%, those 88 are actually getting a higher vote than people in another city, in another district. And what's even more unfortunate is that you're taking away that, you're diminishing the vote in places where there are no prisons, and that's where most people are going back to. That's where most of the impoverished communities are. And so even though you don't have the right to vote, you're still being politicized, and people are still counting you, but they're counting you with ulterior motives. And I just think that, for us to take a look at, and I was going to talk about the history too, and I just want to say one thing about the history. I agree with Hans that a lot of voter disenfranchisement was not birthed based on racial discrimination, but it was expanded. So even in Virginia, even though it wasn't the reason why, we did expand felonies. So for example, we started looking at larceny was a felony, but then we started making it, well, petty larceny is a felony. So we started expanding what a felony is so that it applies to more people. Even though the underlying reason for the law was that, yes, voter disenfranchisement came from Greece, went to Europe, went to England, came to the United States, adopted civil death. We had a lot of things, and it kind of became what it was. And so most of the states had voter disenfranchisement laws, but they were expanded during Reconstruction. And so I think, I'm going to be quiet now because I could probably talk for a while, but I just want to leave you with this quote, which is by Lyndon Johnson. "A man without a vote is a man without protection. He is virtually helpless. Out of such feelings of helplessness were revolutions born."
Thank you, Jesse. Oh,
Well, first, thank you so much for having me. I don't believe anyone from the ACLU of Virginia has ever spoken at Regent. My colleagues call me a little bit brave, but I actually really appreciate it because I really like speaking to diverse audiences and providing a perspective, and I really appreciate diversity back to me and really hearing from other sorts of philosophies and starting points in life. So to that end, I really appreciate the opportunity. So the ACLU of Virginia has been advocating, well, the ACLU generally, but the ACLU of Virginia, which I work for, has been advocating for the right to vote since its inception. And the ACLU believes that the right to vote is fundamental. Just from a philosophical starting ground, we just don't believe it should be stripped. We're all so privileged to be either born in this country or become naturalized citizens and to have that right to vote. And we don't believe that that right being so important that any obstacle or burden should be put in front of it, or there should be very minimal burdens or obstacles put in front of that. And it just seems as though through the last decades and centuries in this country, more and more of those burdens and obstacles are being put in front of the right to vote. And like all rights in our country, there's ebbs and flows, right? So we can talk about that a little bit. But when we talk about the right to vote in Virginia and restoration of rights, the ACLU has been out front and active on this issue. We're a nonpartisan, nonprofit organization, and we've worked specifically, in my experience, I've been at the ACLU of Virginia for 10 years, and I wear many different hats with respect to voting rights. I litigate on voting rights, I serve as a lobbyist before the General Assembly, I also work in the Governor McAuliffe's and formerly Governor McDonald's Virginia Restoration of Rights Working Group for advocates that are interested in the issue. And that brought together a pretty diverse group of organizations to help with perspectives, concerns, how do you figure out logistical issues with implementing reforms throughout the last 3 administrations. So starting within the framework in which we work, right? So we don't all retain the right to vote in this state when we get convicted of a felony. So throughout the whole, 3 administrations, I'll start there, there's been all of these burdens and these obstacles. And I want to start when I began this work in Virginia. There were the waiting periods, the requirements for letters of recommendation, the financial requirements. All of these things were such huge barriers for folks, even if those folks knew about them. So right there, right out the gate, you're sort of set up to lose. And sort of, as Jesse alluded to, if you get incarcerated, which I'm glad you brought up that point. Most people are just like ordinary folks. They find themselves in a situation, and yes, they made a bad choice. But most folks who get convicted of a felony never actually end up incarcerated. But they've got this status, right? And I was actually just at a meeting of the Virginia Department of Corrections. Virginia has, and they brag about this, compared to other states, a very low rate of recidivism. And there's probably many reasons for that. We incarcerate a lot of folks here. And as Jesse said as well, and as the Attorney General Puccinelli said back in 2013, we have an epidemic of felonizing every crime. So disproportionately, you have 1 in 5 African Americans of voting age in Virginia disenfranchised. And you go to African American men, it's 1 in 4. You've got 20% of Virginians of voting age disenfranchised. And the collateral consequences that flow from that are obviously numerous. And I know that probably, knowing my audience here, that maybe we're not going to agree with the philosophical starting point that this is a fundamental right and it should never be taken away from you. So I want to talk about some of the reasons why restoration of rights is so important and why nationwide the movement has gone for restoration of rights as a bipartisan, everybody's on board sort of issue, and why Virginia is really lagging behind. And frankly, it's a bit embarrassing to be one of 4 states that permanently disenfranchises folks. And let's talk about, the fact that when you get convicted of a felony, let's say you go to prison, when you leave prison, nobody makes you wait 3 years to get a job. You get a job, if you find a job, you start paying taxes immediately. No one said you get a reprieve from paying taxes for 3 years. Being a part of a citizen of our communities and part of rehabilitation, which, by the way, as a taxpayer, and I assume all of you are too, we pay for prisons, we pay for correctional guards, we pay for programming to rehabilitate people so that when they re-enter society, they can be successful, productive members of our community. I don't think that prohibiting someone from being able to cast a vote is conducive to those goals. And social science and the Department of Justice has also stated, when you give someone back their full life, their full civic life, they're less likely to reoffend, they're more likely to be re-engaged in their communities. It is better for our nation and our democracy as a whole. So I think that that's sort of the policy perspective I wanted to put out there, but I'll talk a little bit about the legal perspective from the ACLU of Virginia. We filed an amicus brief supporting the governor's executive order this summer. And our arguments were twofold. One, dealing with whether or not the governor had the constitutional authority to do what he did. And I would argue that he did not issue a blanket executive order. We argued that he had the authority to do so, but that's not actually what he did. So his executive order said, if you completed your term of incarceration and you were released from supervised probation or parole, your rights were restored. So it was not a broad blanket automatically restoring voting rights back to the estimated 450,000 plus individuals who have a felony conviction in Virginia. It was estimated to affect about 206,000 individuals. So we argued, one, he had the authority to do a blanket restoration, but even if the court didn't find that, he didn't, because it was the sort of like, it's an individualized review. These eligible individuals completed these two criteria before they were able to have their rights restored. And the second point we made, really going to this, is that the goals of our criminal justice system are to rehabilitate folks, and that this is a fundamental part of doing that, creating a full citizen once they've met these two criteria. We ended our argument in our brief on just talking about, we touched on this a bit, we left it to historians to really argue more eloquently, but the history of restoration of rights and the racial impact, the discriminatory racial impact. And as Jesse stated, yeah, and Hans has stated, we've had felon disenfranchisement provisions in laws and constitutions, and it dates back to Europe. But we really, really made an art of it as far as who it applied to in Virginia. And I don't think anyone can really argue with Virginia's really tortured past with enacting poll taxes, literacy tests. So today when I think about when people come to me and say, well, shouldn't someone who wants their rights back have to pay back restitution fines, fees before they get it back, which was a requirement a few administrations ago, we always make really clear in our advocacy, you're right, they do. But here's the thing, we don't think your right to vote, your restoration of your right should be conditioned on repayment of fines, fees, or restitution. That doesn't mean that we're saying that individual isn't legally obligated. They are always going to be legally obligated to pay back a victim and the courts. We just don't think, if the goal is to take someone and put them back into society as a productive full member, the right to vote should not be conditioned on money, and that's why we call it a modern day poll tax. And I think that when we talk about the history, I would encourage anyone who's interested to read all of the amicus briefs that were submitted to the McAuliffe lawsuit this summer. There's some really interesting perspectives, and there's a diversity of experts that submit their briefs, one by Professor Howard, who, good lawyers can make arguments on both sides, right? And he makes great arguments as to why this Constitution is still infected with discriminatory intent. So in the it's my understanding that in the 1970 Constitution, they didn't even touch on disenfranchisement. But if you go back to the 1901 and 02, when you have legislators that make statements that say explicitly keep the darky out of the political process with regard to that provision, that permeates our society until it's gone. And I wanted to touch on something that we haven't actually talked about, is how do we fix this problem permanently? Regardless of what the process should be to get your rights restored, this is all incumbent on who's the governor of Virginia. And when we talk about states' rights and checks and balances between the legislature and the governor and the judiciary, the next governor could be, just as Jesse's experience highlights, what if that person is completely like nothing? Nobody gets their rights back at all. What if the next governor is, I don't know how, I think that McCall might have, I know that the next governor, if they wanted to be more expansive, could say automatic restoration to everyone incarcerated, no conditions whatsoever. It's important to keep in mind McCall did have two conditions in place. So to take care of that problem, it's really upon us to call on our legislators and provide our perspective and our voice and say, I need you to support a constitutional proposal to take this out of the Constitution. One individual in Virginia has the discretionary ability to say yes to someone and no to someone else. They have the complete ability to do that. And no matter what your perspective is on the issue, should it be solely in one person's hands? So I think I'll end there so we can get to questions.
Okay, well, first I'm going to allow each of you to make a few comments as to your fellow panelists' comments, so we'll start getting down to Hans.
One point I would like to make is, with all due respect to Jesse, I'm gonna beat up on him. He says all these decisions were not made by the people. That is untrue. The provisions in Virginia that give the authority to the governor on this issue, to take away your right to vote, and say you can't serve on a jury, all of those were done through acts of the legislature, who are the elected representatives of the people. So the idea that this just is some arbitrary thing that occurred, sorry, no, that's the way democracy works. We, the people of the Commonwealth, made the decision to put in these different provisions. And if you believe they should be changed, yes, go to the legislature and get them to change it. But the governor doesn't have unilateral power to just do it on his own, particularly when the law and the Constitution says you can't do that. Second, as Hope made very clear, the ACL believes you should be even able to vote in prison, which she says is such a fundamental right. Well, I'll agree it's a fundamental right. But a person who is in prison because they committed a felony is there because, again, they made the conscious, intentional decision to violate the law, to injure another person often, and to go against the rules of a civil society that we have decided should govern our behavior. So I don't think it's a good idea that someone who has that kind of a cavalier attitude towards the law should have the ability in the ballot booth to help determine what those laws are. Because that's what you're doing in the ballot booth. You're voting for the individuals who go to the city councils, the county commission districts, to the state legislature to formulate the laws and ordinances under which we live. So I don't see from a principled standpoint that there's anything wrong with taking away that right to vote. In fact, I think that ought to be done until that individual has proven that they now consciously and knowingly agree to abide by the rules of the civil society that we have put together. Now, there's all this discussion that this has a disproportionate impact on minorities, particularly African Americans. Well, as the court said in the Johnson v. Bush case, this was the lawsuit that challenged Florida's rules, in fact, in 2005. That was dismissed by the court because the court said the reason these individuals have lost their right to vote is not because of discriminatory conduct, it's because those individuals made the conscious decision to break the law, and the result was they lost their right to vote. And I never hear anyone talk about the fact that you can look up the statistics yourself on this. The victims of violent crimes are disproportionately women and African Americans. Those are the people who are the victims, and there's no debt to them that can ever be repaid by that felon. What happens in prison is not the payment of a debt. It's not a debt-making deal. It's punishment. And the debt that is owed by that felon is to their victims. And that's a debt that in many cases can never be repaid.
I can.
Go ahead.
And I assume, we'll obviously just philosophically disagree, but I think my starting point, and for many, I think that come from my perspective or opinion about this, is that when you commit a crime and you get convicted and you get sentenced to a punishment, that is the punishment, right? But you don't, and the judge or the jury gives you that, right? You're in prison for X amount, you have to serve this many years of probation, these are the conditions of your probation. All of that stuff is intrinsically tied to your criminal conviction. The right to vote, disregarding, yes, when you get convicted of these provisions in state constitutions to take away your right to vote as a matter of your conviction status isn't inherently a civil act as a citizen of this country. So philosophically, I just start from a different starting point. They're not tied, they're apples and oranges. And I think, you know, when I speak to my friends that agree with me on the end, not so much the means, you don't stop being a member of our country, our state, our community, simply because you did something wrong. We're a nation of second chances. You don't stop being an American citizen. And here's the other sort of irony or catch-22 about all of this, is that this is a population that I think it could be a real force of change and contributing members, and who needs that the most when you think about second chances and redemption and re-entering communities and making the Commonwealth of Virginia better and more civilly engaged, which I think, regardless of where you come from on the issue, everyone could agree we need more of.
Justin?
Yeah, just a couple things. I agree with Hans that there are several collateral consequences that, you know, are passed by the legislature. Those are very few and far between. The issue of voting, obviously, sitting on a jury, those types of things are passed by the legislature, but there are very, very few. You can probably count them on one hand. The rest of the 44,000 are not passed by the legislature. And they are passed by, it could be any number of agencies, occupational licensing boards, the list goes on and on. And so what I find interesting is the United States Supreme Court has determined that in some instances where a collateral consequence is so egregious or has such a large impact on an individual, like deportation, that if the lawyer did not advise their client of that would be a risk of pleading guilty, that they have an inefficient assistance of counsel. And so what I think that does is that cracks open the door to say some of these collateral consequences may in fact be so large that you've got to at least have notice and some kind of further due process on them. And so I think that door has been cracked open. The United States Supreme Court has certainly left some room there to expand on that. They also applied it, or states have then applied it in instances of lifelong supervision. So if you plead guilty to a crime and as a result of pleading guilty, you will be on parole for the rest of your life. If you are not informed that that is in fact a sanction that will be on you, not just a prison sentence, then you have, and your lawyer did not advise you of that, then you have an inefficient assistance of counsel claim. And so I think that that's just important to understand. And a lot of these collateral consequences, and personally I realize that a lot of these are just cultural too. They're not just in the law. They're cultural. We all have cultural stigmas. We all have perceptions. We all view people a certain way. I mean, if I came in here, everybody would probably think Hans was a person. No, you know, but we have these perceptions and these stereotypes. And so really we've got to start changing how we view people who've been through a criminal justice system. Because I mentioned before, it's 1 in 4 adults. And, I disagree that if you find yourself in prison, I think that to take away the right to vote is okay. What I don't think is okay is that for us to continually dangle the carrot and to say, well, maybe you'll get it back. Maybe, because you have people like me who are going to burn around every corner on that second chance road and say, okay, I've done it. And then once you get there, you realize there's another agency, there's another individual, there's somebody else asking for a pound of flesh. And pretty soon you just get lean. I mean, I only have so much I can give, or I get old, I get tired of fighting. And so, you just, time after time after time after time, it gets so tiring. And so you're thinking, I'm doing everything I'm supposed to do, this is what you said. And so the analogy I like to give is, unfortunately I spent like 9 days in the hole, solitary confinement, the shoe, bad sink, whatever you want to call it. Okay, when I was incarcerated. And when you're in prison, particularly in the cell I was in when I was in solitary, there's this little window. They gotta let so much sunlight in apparently. So there's this little window that you try to see out of. It lets some sunlight in, but it's distorted. You can't see out of it. You may be lucky if you see some images, but you can't see color. All you can see is it's light or dark. So I guarantee I wasn't the first one to do this, but I pressed my face against it because you just get so bored. It's so loud in there, you just want to try to forget everything. But I press my face against it, and I would just try to look out, right? Just trying to see something out there. And that's what our system gives everybody who walks out of the criminal justice system. You get that window. You get that lens. As soon as you step out of our criminal justice system, that's what you see. Now, when you're in, you think, man, I'm going to go do this, I'm going to go to that, I'm going to become this, I'm going to work hard, I'm going to do the right thing. But you're looking out that window. You realize as soon as you step across that prison threshold, that's the lens you get. That's what our system gives everybody that comes out. And we've got to give them something else. Nobody deserves a second chance, but everybody deserves an opportunity.
And can I ask an informal poll? Has anyone in this room provided direct services in the past to someone who wanted to get their rights back to the application process? So, two, okay. So I also used to do that when there was a more lengthy process. And let me tell you, when someone would call our office and I was charged with helping them navigate the application process, these were very motivated individuals who wanted to get the right to vote back, but the discretionary obstacles put in place by previous administrations were so burdensome. And the worst case scenarios were individuals that would call and they were convicted maybe 30 or 40 years ago, and their records are no longer available, or they're lost in some warehouse because now everything is electronic. So they couldn't even prove that they completed probation, or they didn't have that letter anymore. They couldn't find records. And that was only one, and if you remember 3 administrations ago, it was a 13-page application that required all of the supporting documentation. So all of these sorts of obstacles and burdens, I mean, and there's a certain amount, I think, that people maybe could agree to in this room, that there's privilege in this room, that you're all in law school, I assume. We're all coming from an educated perspective, that you can kind of figure out how to do it. It might be harder, but for a large percentage of the population, especially people that would contact our office for looking for help, just help to get the right documents, or the circuit court clerk who wasn't very helpful or whatnot, is that it's a population that needs help. They're trying to re-enter society and be successful, and that opportunity and that window shortens. And so, funny enough, like you were saying, we all make assumptions about who is and who isn't. You never once thought, if I went to prison, I didn't, but we all make those sorts of, assumptions about people, and nobody thinks about the 18-year-old that got caught with simple possession of pot and then 30 years later still can't vote. We all make mistakes in life.
Anything else from anyone? We're going to open it up now for questions. And do we have any questions from people who are watching by the web? No questions so far. Okay, let's open it up first then to our folks here. I saw this hand first over here.
So historically, voter turnout has been pretty low, especially during certain age groups. So why particularly is the right to vote so important when we don't really have people coming out in the numbers that we expect?
Well, I don't think that whether people decide to use the right or not is predicated on who gets the right. I think that, and personally, I think that it's a great opportunity for conservatives, to be quite honest, to get people out there. I think if conservatives were to reach out to people who have been through the criminal justice system, we'd get more votes. We don't do that. I think there are a couple people that do that, like Rand Paul. I think he does a good job at trying to do that. He's good in these issues. I think Ken Cuccinelli was good in these issues. And so I think that there's opportunity here, but the fact that whether people are doing it or exercising that right, I think is completely separate from having the right. So.
Yeah.
Jesse and I certainly agree on that. But I'll tell you something interesting about that. The U.S. Census Bureau does surveys after federal elections. And in those surveys, they go and they survey people who didn't vote. And you'll see all these false narratives in the press and elsewhere that the reason we have low turnout is because there's supposedly all these barriers, to keep people from being able to register and stuff. That is just not true. It's easy as can be to register to vote in this country. What those surveys ask is is directly to people, why didn't you register, why didn't you vote? The number of people who say, well, I didn't vote, I didn't register because I had an administrative issue, problem, getting registered, is a tiny percentage at the very bottom of the survey. The vast majority of people say they didn't vote for 3 reasons, and this encompasses most people in the survey. I'm not interested in politics and elections. I don't like the candidates, and I don't think it'll make a difference in my life. That's a societal, cultural problem that we have to deal with if we want to increase turnout. And when a candidate actually runs for office that excites people, we actually do get high turnout. That's why in 2008, we had the highest turnout in presidential elections since the early 1960s. That's because Barack Obama excited people, got them out to vote. But the issue is not one of the procedural details of registering and voting. It's changing the societal outlook and making people realize that they got a reason to vote.
I actually would agree with Hans for the most part on that. I do think there are the occasional blips with registration training. I mean, our office encounters registration training issues all the time, which end up in faulty registrations. We have to go fix them, but I do think, while it's not directly related to restoration rates, I think it's a societal and cultural issue. I think from my own perspective, if you're raised in a family that believes that voting is really important, and not just during the presidential year, but every election, they're gonna go do that no matter what. And yeah, I do think that there's, even within, like, say, my own personal experience and family members who I think get turned off by candidate, or just the political process, and there's probably a lot of people right now, regardless of who you intend to vote for, that are just tired of hearing about it. So I think it's in other countries, and the thing is, I'm not an expert or historian on voter turnout, but I would maybe guess in previous decades, voter turnout was much higher because as you get closer to the 60s and you think about the civil rights movement and people who fought and actually died for the right to vote. There's a lot of rights I think that my generation, your generation, maybe take for granted and are more apathetic and indifferent to.
Thank you. Yes, sir.
My question comes from something that Jesse said about, and something that Hope had touched on as well, about the financial difficulties that convicts have after they are released from the criminal justice system, how difficult it is to obtain sources of income in order to pay for housing, pay these administrative fees. What are the sort of steps that you guys have in mind for each particular perspective that can be done without interfering with the private ownership of business?
Well, I'll tell you about an interesting program in Wisconsin that I learned about. I was at a conference up there recently, and there was a guy there, a great guy, who started this program in Wisconsin where he goes to cities in the state, and he buys from the city distressed properties for like $1. So these are housed homes that people have basically abandoned. And when folks come out of prison and get into his program, he has a deal with them whereby they all work together on restoring each of these houses. So these felons are there to help restore the house. And the deal is if they work on restoring the house, then they get to own the house. And it's that kind of thing. It's been monumentally successful, and it's very important because without a place to live, it's hard to work and hold a job and things like that. And it's programs like that I think outside the usual box, that can be very, very effective at home. I thought it was one of the best programs I've seen. Just out of that.
Yeah, no, that's a great program. The problem is that you can't give that to everybody. So there's other good programs too, like the prison entrepreneurship program. I don't know if you've heard of that. They make business pitches. They teach them basic business principles. They make business pitches, and then you'll get funded. You'll get some venture capitalists to kind of give some money to kind of do your business. There's Defy Ventures, which kind of does the same type of thing. But your question is there's lots of layers there, because it's got to start the day you come into the criminal justice system. And when you block out of the criminal justice system, there has to be legitimate opportunities. So I think the question we have to ask is, what are people doing when they're in the criminal justice system? Is it productive? Is it actually producing, going to provide them opportunities to actually be self-sufficient? Because as a civil society, we want people to be self-sufficient. I want people to reach their highest potential. It's better for me as a taxpayer, it's better for everybody. So we need to make sure that those opportunities are available, and it's a very, very long conversation we have on that, but yeah.
I think we need a couple of hours.
Yeah.
Right, and I think that from my perspective, in at least the direct services I've provided, for folks who got convicted, say, 30 years ago, okay, and then they enter a prison, and the interest on their fines, fees, and restitution starts, so like at the outside, and then, and that's high interest rates, by the way, depending on the circuit or your state you're convicted, and they're compounded every single day. So when they're out, they're never going to be able to repay that if they don't, even if they have a great skill set, because then you try to find a job. So I think that, you know, many employers, they ask, are you a felon, right off the bat? And I'm not saying that, I think that ban the box legislation helps. In fact, it doesn't mean you have to hire a felon, by the way, which I think a lot of people think that's the case. It just means it's not an automatic disqualifier. It's giving that person the opportunity to, if they're qualified as far as their skill set, to interview for that position, to see if they can do that job, right? So it doesn't look at someone's criminal background and see if it's relevant. So for example, the bank's not hiring an embezzler per se, right? But it's things like understanding that when you get assessed fines, fees, and restitution, and you go to prison for a while, not all prisoners get jobs, by the way. And those that are very lucky to get jobs in prison, pay 3 cents an hour? I mean, you're set up to fail. So I think that ban the box in many cities and states is having somewhat of a good impact on people, at least being able to get their foot in the door of a good paying job.
Your question, and then I know he has to go to
Yeah.
his class.
You had mentioned something, this is for all of you. You had mentioned that your position is that prison is a rehabilitation.
Well, it's one of the.
It's one of that, notwithstanding that perspective, whether you agree or disagree with that perspective, if you stay on that perspective and say, how can we rehabilitate prisoners in light of recidivism rates? Is there a consensus between the three positions where there could be some measure of restoration based on something that has to be done by the incarcerated after they get out in light of what the voters want and what different perspectives want? So I'm looking for a consensus. Is there one?
I don't think that you would find one there because, again.
Give me one perspective that you all could agree on. Forget about the whole thing or the time, but is there one perspective that you guys could all agree on?
I think that we could probably all agree that people deserve second chances.
Yeah.
But as far as a
That's too
checklist,
broad.
yeah, as far as a checklist of what, for example, if someone was convicted of felony and went to prison, if they accomplished X, Y, Z, they could come out and have their right to vote right away. That would not be my position, given that, again, the right to vote is fundamental and, we believe it shouldn't be taken away. But given the working within the framework that we have, you are convicted of a felony, once you're done serving your sentence and your probation, you should be able to vote.
I think we can probably agree there's a problem. But I think that's actually a good starting point.
Yeah.
I mean, that is a starting point. And I think that, you're gonna have these varying conversations underneath that, but just acknowledging that, I think is what we actually see on Capitol Hill and in the States.
I believe in second chances, I believe in redemption. I just think you need to show that you deserve that second chance. That's the difference.
Yes, sir. Did you want to comment on this, I think?
Yeah, I have a question. I'm probably 50-50 on this issue. But something you just said, you said you gotta show you deserve your rights. Now, each one of you talked about rights. Now, in my understanding, a right is something that is probably inherent and doesn't hold an obligation to someone else. Now, we understand, probably a lot of us in this room understand that I would say voting is probably a natural right, that it is having the ability to say who represents you is a natural right. So what's the middle ground? How, if I did something wrong, that shouldn't, that shouldn't take away, my ability to say, hey, President Obama should represent me. So what's going to be the middle ground? I know this is a big issue. So what is going to be that middle ground?
Well, I'm not sure there is a middle ground. I mean, if you look at what happens in the states, 48 take away your right to vote when you're incarcerated, 2 don't. They never take that right away. And what's related to this, something I disagree with Hope on. She says, when you're convicted of a felony, your punishment is going to prison. No. Society as a whole has decided that in addition to the possibility of prison, you are also going to suffer certain civil penalties. And those certain civil penalties are all the things we've talked about. Losing the right to vote, losing the right to sit on a jury, losing your Second Amendment right, which is a fundamental right under the Bill of Rights to own a gun. So we've decided, we as a society can change that view. And voters in Vermont and Maine have changed their view on that. But the point is that it's not just being in prison as your punishment, it's the loss of certain civil rights, and we as a society have decided that that's what we're gonna do.
It sounds to me like you're more than 50-50, sounds like you're on my side. If you're already gonna say it's a natural right, and I don't know if I would agree with you there, but I get what you're trying to ground it in. But I'm saying, if you're gonna say that, then you're gonna have to follow that all the way through and say, well, come over to our side.
And I think you actually are on my side because
Don't spread that around.
here's the thing, in my perfect world, right, this is not the system we're working with it, right? And if you do something wrong, you never lose your right to vote because it's inherent to your fundamental being, right? But that's not the system we're in, right? And some argue that perhaps we need a new constitutional amendment to the US Constitution, very explicitly saying you have an absolute right to vote. And I would also argue that, when you get convicted of a felony and you have to be punished, however it may be, you never stop being a citizen of the state in this country. You should have a voice.
I think some of the issues we have here is just embedded in the criminal justice system as a whole. So we have so many disparities in the system. So for example, in Iowa, the joke was in Iowa, if you got caught selling meth in Black Hawk County, you're going down. But if you get caught in Johnson County, one county over, you might get probation. So there are so many of these discretionary decisions that are made throughout the criminal justice system that heavily impact a person's life, and it creates a diverse, two diverse journeys. And that's a problem. So we've got to work to say, I'm a strong conservative, and I believe in punishment in the criminal justice system. I've been through the criminal justice system. I believe that it creates dignity as me as a human being for you to punish me. But you've got to punish me proportionally. The minute you don't punish me enough, or the minute you punish me more, you're either saying someone else is worth more than me, or that I'm worth less. So we've got to figure out how to bring proportionality back. And part of proportionality is talking about when is that punishment over. And if you were to just tell me that, and I knew it actually meant something, I would pursue it. And I think I know hundreds and hundreds and hundreds of people, I've been to prisons all across this country, who would breathe a sigh of relief to know that they can see an end in something.
And I just say, I agree with Jesse, with Hope too, on the fact that, and in fact, you should know, the Heritage Foundation and the ACLU are part of this broad coalition on over-criminalization. I mean, I agree that we have over-criminalized to an extent that we shouldn't. I mean, the worst abuse of power going on today is the fact that federal regulatory agencies are able to make things a crime by issuing regulations, which is just such an abuse of power. It's just bad. But that doesn't mean you get rid of this issue. What that means, you reform the criminal justice system. And for saying, you're saying that, well, it's a natural right, you shouldn't lose it. Well, I have a natural right to be free. That's a basic part of what we believe is a natural right, the ability to be free and pursue liberty. But I can lose that right and be sent to prison if I commit a crime. And that's the same thing that's happening with losing the right to vote.
Yes, sir.
My question was with the vast problem that we have with repeat offenders. So, Ms. Hope, you were saying that you believe basically once you're out of prison, you should have all the rights that you had before you entered into prison. But with repeat offenders, do you believe that for example, a 3-year period of waiting for them to regain their rights would be fair, seeing as they are repeat offenders and they obviously have not learned from their previous mistakes?
No, I would not agree with that position, and let me explain. It's very principle. It's, one, I don't believe you should ever lose your right to vote, but in working within our existing system, once you're convicted of a felony and once you're done with that term of incarceration and supervised probation, or parole, you should be able to have your right to vote back. So I don't necessarily, I think you gotta start at the starting point that I don't look at it as, voting should be tied to a crime or a repeat crime necessarily. And you said something about reoffending or recidivism and how, here's the thing. We live in a rule of law society, and I can agree with my colleagues too. Like when you commit a crime, you have to go through our judiciary system and be punished appropriately. But I think that the right to vote is just so important that you don't stop being an American with that right to vote simply based on a status.
Can I ask a question, actually? I want to ask you a question. Do you believe that that a person's Second Amendment right should also be restored along with the other rights?
Well, I think that's really interesting. So this is a huge debate actually within the ACLU. So as I understand the ACLU, it is actually being debated internally. There are some ACLU affiliates that actually advocate, they have a separate policy position that they advocate on your right to bear arms. Our particular affiliate agrees with National that it is a collective military right, disagrees with, and does not take an active stance on that. But when you were talking about this earlier today, it's also above my pay grade to even say any more than that. So I'll say that. But I will say that it is a huge issue of contention within the ACLU and different affiliates. And I was actually just describing to Jesse before this panel that we each sort of have the autonomy to either agree with the National ACLU or disagree. Obviously, 99.9% of the time, independent affiliates agree with National. But with regard to gun rights in Virginia, I think, I understand that a lot of civil libertarians tie gun rights to political rights, to civil rights. And I think it's important to understand that the governor in that provision of the Virginia Constitution talks about political disabilities and the right to get your gun, or you have to petition the circuit court in which you're convicted to get your gun rights back. And that's not something that we deal with. That's regardless of your position, the governor's authority in that particular provision, simply it deals with political disabilities, the right to run for office, right to be on a jury, right to vote, and to be notary public. So I think that it's also important people to know, and we do actually get a lot of calls from people who want help with that. It is a plus factor apparently to the Virginia State Police that once you get your civil rights restored, and you can show that on an application when you're working on your petition to the circuit court, it's a plus factor. I'm not even sure if it's a mandatory thing you have to do to get your gun rights back. But I think we can agree that it's a very contentious issue, and all I can say is that we talk about it ever so often in our affiliate, and we realize that it's a source of conflict for many people. But I don't want to conflate the two with regards to Virginia restoration of rights.
Yes, sir. You had your hand up.
Oh, I had my head up. My question there, it's kind of expanding on that actually, your Second Amendment right And your inherent rights, to, liberty, life, the course which you can take, So how is voting rights such an inherent right, in comparison to life and liberty? How can you equate voting rights if you can't take away voting rights? If you can take away life and liberty, you can't take away voting rights. It just seems really.
I don't think I'm understanding your question.
My question is kind of, how do you compare the two? If the courts can take away your life and your liberty, then you're making an argument that they don't have the power necessary.
Well, I don't think anybody here is making that, or I don't hear anybody making that argument.
Right.
I think, yeah.
I just think they're so, it seems like a very, with voting rights, it seems voting rights just seem much less of a, an inherent right in life.
Sure.
Oh, absolutely, right. And I will say, like, the first thing people do when they come out of prison, they're not like, sign me up to vote. They're like, I need a house and some food to eat and a job, right? You need to live.
But-
But I think maybe answering your question is why I say it's such an inherent right. Think about it this way. We're a rule of law society. We operate within our legislatures, our judiciary, our elected officials. We say when you do something bad against our laws, you have to be convicted and go to prison and serve that sentence. I absolutely believe that. But also inherent in that rule of law society in our great democracy, at the starting point is everybody voting to elect those folks to say what your country says you have to obey by and live by. So that's what I mean by that.
And I think it's a slippery slope a little bit, because if you're gonna compare everything to, well, yeah, the government can kill you, so, yeah, they can do anything that they want to do. So they gotta be careful walking down that road, but I do think, I get what you're saying. So I think that but you have to, what we're trying to say is, when is that applicable? When should you be able to do that? And who should be able to do that? I know Hope brought that up, but that's one of the things we didn't talk about. Should it be the executive branch? I encourage you guys to think that through. Because now, if you want to get a constitutional amendment, usually it's by referendum, depends on the state, sometimes it's a referendum and the legislature, it just depends. So it's very, very difficult. But who should have that authority, and do we want to have this jostling back?
And I will talk about the discretionary problem of one governor to make this process. When Jesse was talking about, it's not just what we can find, what we can read in the law and how it's practiced in theory. I'll give you a great example, even though it is not our subject tonight, the death penalty in Virginia. Depending on where you commit your crime, for example, one Commonwealth's attorney may pursue capital punishment, and then if you commit that murder in another jurisdiction, no. So I think what, sort of highlights restoration of rights is that it's not just about the right to vote, it's permeated this discretionary power of our entire criminal justice system. It's just so pervasively a problem in every layer.
I know we're getting close to the
Got
time.
maybe one more question, two if they're quick. Go ahead.
These two, because they had their hands up. Don't know who got first.
Thank you. My name's Keith Bryce, and I'm not a law student. Actually, Jesse invited me to come tonight. I just known Jesse through his ministry. I'm 54 years old, college educated. I actually went to a semester in 1986 at Regent University before I got into, started my career. I come at it from a little bit different angle. In 1980, I cast my first vote for Ronald Reagan, and I voted in every election up to this point, very proudly, as one of my rights as a citizen. In 2012, I was convicted of a first-degree felony. I was sentenced to 10 years in the Texas prison system. I served 16 months as a prisoner dressed in white. So I come at a little bit different angle than probably most of everybody except a few of us in the room. When I look at voting rights, my whole perspective of everything changed when I turned myself into Harris County Sheriff's and then ended up in the Texas prison system. Hope, before that, I was a staunch conservative. I'm still very conservative politically, but I've become very empathetic to what you're saying tonight. Of course, what Jesse says tonight, I come from a Christian background. But one word that comes out to me when we're restoring rights for felons, which I do not have the right to vote, nor do I have the right to bear an arm, even though I did not commit an aggravated crime. And that's okay with me. I understand that. I accepted my crime. I pled guilty to what I did. I was wrong. My one and only run-in with the law. I lost everything. I lost my family. I lost my career, I lost all my wealth, my net worth. I began over at the age of about 50 when I walked out of the Walls unit in Huntsville, Texas, with nothing on my person except the clothes I had on my back and the $50 check that the state of Texas gave me. Luckily, before I went into and was incarcerated, I worked for a gentleman in Southeast Texas who extended me a job, and by the grace of God, I'm in Virginia, remarried, and have a career here in Virginia. But one word that stands out to me when we talk about felons' rights and their right to vote is dignity. One of the hardest things to gain back in your life is your dignity. When you step out as a quote-unquote free person, everybody that you come in contact with, you become paranoid, thinking that they know about your felony conviction. And you want to hide that for a while until you gain the courage to be able to share it with other people. The walk that you walk through, like Jesse says, it does give you dignity after you've walked in it for a while. But dignity.
Mr. Price, do you have a question?
Yeah, I do. The right to vote is a dignity. How do we correct that? Hans, you said it's up to somebody else judging me to see if I'm ready to vote. But voting is my voice. It's my only voice. And it's felons' only voice for any change. It seems to me that the right to vote is minor. How do I get my voice back in a practical, step-by-step process? Is there an amendment that we can make? Is there a process that we can go through that says after 3 years you apply, after 4 years? I think in the state of Texas I have to serve my complete 10 years.
And I can actually answer this actually practical, concrete steps. In the ACLU of Virginia's amicus, and I encourage you to read it, we have 3 affiants in there who were affected by the order. And dignity is all they talk about. And the first thing is that I say in all the issues I work in, which is specifically actually solitary and voting rights, is people before status. So if you notice, I say individuals convicted of felonies, not felons, not offenders, not ex-offenders. And I know that may sound silly to some folks, but in the advocacy community, it gives people I'm saying you're a person before you were that status. So that's sort of something I'll throw out there. The other point about it is, I would say, is reading that amicus brief and our 3 affiants and their stories, just being brave with your story. To be honest, I don't think that we do a great job with public education in this state with regards to voting rights and the restoration of rights issue. And that's been a sticking point of the ACLU and any administration, legislature, is educating the public that when you think about someone who's been convicted of a felony, you're thinking about some serial killer who's like the worst person ever. And there are so many people that have felony convictions that are absent that mistake. And yeah, it's a mistake. It was a bad act, right? Are in our community, are your neighbors, are people in your church, are people in your alumni associations. That the face of a felony conviction is something that people hide because you feel as though you're going to be judged the rest of your life. And I think that taking those sort of concrete steps, and I think it's on the responsibility of the state as we talk about restoration issues and how someone gets their rights back, to really educate the public that this isn't like the worst case scenario person who you think never deserves a second chance. This is a huge portion of your community. Like I said, Virginia has a huge disenfranchised population. It's over 7% at this point, voting age. And like I said, you can't ignore the fact that 20% of African Americans in Virginia voting age are disenfranchised. So I think that you start by raising public awareness and talking about this in your churches and in your classrooms and in your voluntary associations, calling your legislators to propose constitutional amendments reforming the process. I think that really small step of talking about people as people before their felon status is the first step.
Yeah, just real quick, I agree with that on the language issue, but also I think it's If you take a man's dignity, he'll take it back somehow. I saw it in the prison system. If you take a man's dignity, he will take it back. He will get it back somehow, either by violence or either by some other means that we provide. And so I think it's time, there's enough people in the United States that have been affected by the criminal justice system, that it's time for us to insert that voice. And I've been proposing for years that we need a PAC. We need a political action committee. There are rules to be played by, even though you don't have a vote, I guarantee you, there are ways to insert our perspectives into the political process, even though it's the 6 million disenfranchised people that will be hurt. So it's providing a counter narrative to what Hope was saying. But it's being able to look at the landscape, call people out and say, it's time for us to kind of lose the shame and stand up, and that's going to take, but it's happening all across the country.
I think that's, all we have time for.
Mr. Moskowitz, if you had one last closing
No,
comment.
I'm not already 5 minutes back. I will just tell you that if you're interested, I brought a copy, it's down here, of a paper that I wrote for the Heritage Foundation on this issue. So if you want greater detail about the constitutional and public policy issues that are raised, please pick up a copy. Otherwise, thanks for having me. Don't forget the internship program.
I just want to say, the Heritage Foundation is great to work with.
And I would also encourage any of you, we have a lot of overlap with a lot of conservative organizations and coalition work with incarceration, over-incarceration, mass incarceration, religious liberty. And to that end, if anybody has any questions or is just interested in knowing more about our standpoint on this issue, I am always happy to answer, whether by email or telephone or now. So thank you.
Anybody, just to appreciate the fact that Hans and Hope both did double duty today. They were participants in a panel at William & Mary on the same topic, so we collaborated with our William & Mary colleagues there. I do also want to thank everybody for coming out. Just real quick before you go, who here is from the government school? Raise your hand. A couple here, a few of your colleagues maybe left earlier. Did they have to go out? Okay. Undergrads, Laura, you got some friends with you, didn't they? And then they left? That's so great to see, okay? And 1Ls? All right, also awesome to see so many 1Ls, undergrads. I would encourage y'all to continue to stay involved, keep coming out to our events. We're being very deliberate about reaching out to the government school and to the undergrads here, and we're really happy to have undergrad reps like Laura being a part of the group and coordinating with the government school. Our next panel, remember, is the 22nd of November. It's on concealed carry on campus, and it will be moderated by Dean Patterson from the government school, and we'll be continuing to work on our webcast outreach and that kind of thing with that. Thanks very much to the board, Rachel, Robin, Chad, Lindsay, thanks for all. You guys are great.
Thank you.